Hello, and thank you for joining us today. This presentation provides a brief introduction to patent claim charts and how they are developed to evaluate intellectual property. At the end of this presentation, we will provide a link for more information at our website, ghbintellect.com. A claim chart is simply an effective tool for analyzing and presenting information regarding a patent claim. There are many different use cases for claim charts. Here, we will be discussing the most prominent ones. Simply put, a claim chart is a tabular or graphical presentation that breaks down a patent claim into its constituent elements or limitations. And for each element, the evidences of use or prior art are presented. The goal of a claim chart is to systematically present the mapping between each claim limitation and the evidences of use, prior art, intent, etc. Depending on the application of the claim chart, the evidences provided are usually to prove and/or analyze the use of the claimed intention in a product, service, or standard, the invalidity of a patent claim, or the intended meaning of each claim limitation, phrase, or word. There is also a cousin of the claim chart called a specification chart or spec chart that we will discuss here briefly. There, instead of the patent claim, we focus on the patent specification or description. A claim chart is used in a variety of patent evaluation cases, including patent infringement analysis or litigation, patent invalidity analysis or litigation, patent licensing and marketing, and claim construction arguments. For infringement analysis and litigation, claim charts help confirm or disconfirm that each limitation of the claim is present in a product, service, or standard. For invalidity analysis and/or litigation, claim charts help confirm or disconfirm the novelty of claims relative to prior art. Depending on the application, the level of detail and due diligence provided in a claim chart, there may be varied significance. For example, in marketing or licensing, far less due diligence is used than in court cases. Claim charts have been required with IP court submissions since 1983 following Summa Graphics Corporation v. U.S. This helps construct clear claim arguments. Although there are many different types of claim charts, three types are most prominent. An evidence of use, or EOU, or infringement chart shows how a product or process accused of infringement contains each claim element to satisfy the all elements test for infringement and is prepared by the plaintiff or patent owner. An invalidity chart or chart of references shows invalidity of a patent due to anticipation or obviousness. It is prepared by a defendant or the party accused of infringing on a patent. A claim construction or claim interpretation chart shows patent specification or technical literature citations with proper interpretations of the language of a claim and is prepared by both plaintiffs and defendants. There are differing levels of claim chart sophistication and required due diligence depending on the intended use. For internal use, preliminary research and analysis to detect potential infringement or prior art allows for quick review and is usually only used as a high-level presentation to internal decision makers. Marketing uses generally include high-level mapping showing the potential for use to buyers or licensees. For licensing or sales purposes, mid-level mapping and analysis are required and may include reverse engineering results. Sufficient details must be included to allow the potential buyer or licensee to determine the value and risk of the IP. When it comes to assertion, defending patent rights or a product against an opposing patent claim is the goal. So, detailed mapping and analysis, including reverse engineering evidence, is needed for legal negotiations between opposing parties. In court litigation, the highest level of due diligence and detail in terms of mapping, analysis, and evidence presentation are required. Claim charts can be presented in a number of formats. The most common formats are table format and graphical format. Typically, a table format is a 2-column, sometimes 3-column table in a word processing software such as Microsoft Word. The left column consists of rows of claim elements, usually separated in the claim by commas or semicolons. The second column contains evidences gathered regarding each claim element. The third column contains comments and arguments made regarding the claim elements, correspondence, and mapping to the evidences presented. If it's a two-column format, the comments are embedded along with the evidences in the second column. However, care should be taken to make sure it is clear to the reader what is a comment and what is an excerpt from an evidentiary source. The graphical format of a claim chart is typically presented in a slide deck, where each slide highlights and focuses on one claim element or part thereof. Evidences of use are shown on each slide and graphically mapped to the relevant parts of the claim element. Again, using very clear formatting differences, the comments are distinguished from the evidences. As an example, you can see here in more detail the table format of an evidence of use chart that outlines very specific claim evidences like a video processor for implementing communication between the video processor and host CPU. The evidence is shown in separate reference sections, each with their own notes. Although this may look simple with only the very first steps of this chart completed, they can be very long and incredibly specific based on the technology being used. The important fact to keep in mind is that all limitations, i.e. requirements, of a claim need to be addressed and shown to be used in a product or services before one can conclude that a claim is being used or infringed upon. As such, every word and phrase in the claim can be very important in this analysis and must be addressed. When it comes to the graphical or slide format, each slide focuses on one claim element. The claim preamble is an exception and may be combined with the first element. If a claim element is rather long or complicated, multiple slides may be dedicated to completely map it. Each limitation is highlighted in the element using a different underlining or highlighting color. It is important to use the same color to identify the relevant evidence found and to make it easy for the reader to follow the logic. Note, this is not Tegra K1 architecture and is used for the purposes of demonstrating a claim chart format only. This was intended to be a very high-level presentation to get you familiar with the topic of claim charts and how they're used in the intellectual property world. I thank you for your interest with this quick overview, and I hope you found it to be valuable. If you have further questions, we are happy to respond. Simply leave us a comment below and I will get back to you as soon as possible. Or if you have other questions about the services or expertise of GHB Intellect, please give us a call at 858-367-3642 or read more at our website, ghbintellect.com. Thank you.